Hello everyone, I'm Himanshi. Welcome back to the channel. In today's video, we will be discussing the landmark judgment on the constitutional validity of animal sports like Jallikattu, Kambala and Bullock-Cart Racing in the states of Tamil Nadu, Karnataka and Maharashtra. This judgment was delivered by a constitutional bench of the Honorable Supreme Court in the case of the Animal Welfare Board of India and Others versus Union of India and Another by Honorable Mr. Justice Anirudh Bose on 18th of May 2023, wherein the constitutional validity of the amendments made to the Prevention of Cruelty to Animals Act 1960, which allowed the conduct of these sports, was upheld. The other judges on the bench were Honorable Mr. Justice K.M. Joseph, Honorable Mr. Justice Ajay Rastogi, Honorable Mr. Justice Rishikesh Roy, and Honorable Mr. Justice C.T. Ravi Kumar. Let us first discuss the three animal sports. Let us begin with what is Jallikattu. The name Jallikattu is coined from two words Jalli, which means silver and gold coins, and Kattu, which means tide. A bull is let loose among a crowd of people, and whoever tames it will get the coins tied to its horn. The people who participate in the sport try to hold on to the animal's hump to stop it. Let us now see the definition in the Act. This definition was added by the 2017 Amendment Act. Jallikattu means an event involving bulls conducted with a view to follow tradition and culture on such days from the months of January to May of a calendar year and in such places as may be notified by the state government. It includes Manjuviratu, Vadamadu and Erudhu Vidum Visa. Let us now discuss what is Kambala. Kambala is a buffalo race event popular in coastal Karnataka districts. Kambala is performed on two parallel race tracks filled with slushy water. Buffaloes are usually raised in pairs during a Kambala buffalo race event held together with plows and ropes. The Kambala buffaloes can cover a 140-meter racetrack in less than 12 seconds. The jockey or Kambala runner is the man commanding the buffaloes and races along with them. The runner stands on a wooden plank supported to the setup that holds two buffaloes together. He controls the buffaloes with a whip or ropes. Two teams of buffaloes along with their jockeys race towards the finish line on the two parallel racetracks. Let us now see the definition in the Act. This was also added by the amendment. Kambala means the traditional sports event involving buffaloes race normally held as a part of tradition and culture in the state on such days and places as may be notified by the state government. Now coming to Bullock-Cart Racing in Maharashtra. It is a cultural activity and popular amongst farming community in Maharashtra. Local bullock cart owners and farmers arrange this race mostly in their villages. Bullock cart racing starts from November and lasts till May. Four incredibly fast bulls pull the cart for a distance of 350 to 450 feet on the racing track, and the team with the highest speed is considered the winner. Each team dashes across the tracks one at a time, and most of them finish the race in around 10 to 15 seconds. Let us now see the definition in the Act. Bullock-Cart race means an event involving bulls or bullocks to conduct a race, whether tied to cart with the help of wooden yoke or not, with or without a cartman, with a view to follow tradition and culture on such days and in any district where it is being traditionally held at such places as may be previously approved by the district collector, and also known as Belgada Shariat, Chakri and Shankarpat in the state of Maharashtra. I hope you have broadly understood what all animal sports have been taken into consideration in the judgment. Let us now discuss the backdrop of events which led to this judgment before the Constitutional Bench. On 29th March 2006, the Honorable Madras High Court, in the case of K. Munyasamy Thevar versus Deputy Superintendent of Police and another, instituted a statewide ban on Jallikattu. However, soon the Tamil Nadu regulation of Jallikattu Act of 2009 was introduced by the state government to bypass this ban. In the year 2011, the central government declared bulls in the list of animals whose training and exhibition was prohibited. Then, in the year 2014, the Honorable Supreme Court held that the animal sport Jallikattu amounted to cruelty to bulls and therefore banned all similar bull taming and bull racing sports in the country. We'll be coming to this judgment later on. Thereafter, in 2016, the Union Ministry of Environment, Forest and Climate Change revoked its 2012 notification which prohibited bulls as performing animals. And based on this, the Honorable Supreme Court had also ordered the ban in the 2014 judgment. Thereafter, the Tamil Nadu state government passed the Prevention of Cruelty to Animals Act and the rules in 2017. Similarly, it was passed by Maharashtra and Karnataka as well, which was enabling the conduct of the sport. Now, these acts have been challenged before the Honorable Constitutional Bench judgment, which we will be discussing in the video. Now, first, let us come to the 2014 judgment. The judgment of Animal Welfare Board of India versus A. Nagaraj and others was delivered on 7th May 2014. A division bench of the Honorable Supreme Court considered the provisions of Prevention of Cruelty to Animals Act 1960, the Tamil Nadu Regulation of Jallikattu Act 2009, and the notification dated 11 July 2011 issued by the central government under Section 22 Clause 2 of the Prevention of Cruelty to Animals Act 1960. In this case, there were two sets of cases. One set challenging the division bench judgment of the Madras High Court at Madurai dated 9th of March 2007 in the case of K. Munyasamy Thevar versus Superintendent of Police, filed by the Animal Welfare Board of India. Other writ petition filed by PETA, both challenging the validity of Tamil Nadu regulation of Jallikattu Act 2009. And few other writ petitions transferred from the Madras High Court at Madurai, challenging the validity of the Ministry of Environment, Forest and Climate Change notification dated 11th of July 2011. And another set of cases like SLP challenging the division bench judgment of the Bombay High Court dated 12th March 2012 in the case of Gargi Gogoi versus State of Maharashtra, and PIL upholding the ministry's notification dated 11 July 2011 and the corrigendum issued by the government of Maharashtra dated 24th August 2011 prohibiting all Bullock-Cart races, games, training, exhibition, etc. A review petition was filed against the judgment of the Bombay High Court, which was dismissed by the High Court on 26th of November 2012 in the case of Khet Taluk Chalak Malak Singh versus Gargi Gogoi, against which SLP has been filed. Now, coming to this judgment, the Honorable Supreme Court banned Jallikattu and Bullock-Cart race in 2014. It was held that every species has an inherent right to live and shall be protected by law. These sports were held to be contrary to the provisions of Section 3, 11(1)(a) and M of the Prevention of Cruelty to Animals Act 1960. It was held that bulls cannot be used as performing animals, not anatomically designed for such performances. The court also held that Prevention of Cruelty to Animals Act 1960 is a welfare legislation which has to be construed bearing in mind the purpose and object of the act and the directive principles of state policy. And in the matters of welfare legislation, the provisions of law should be liberally construed in favor of the weak and infirm. Now let us refer to these sections one by one, starting with section 3. Section 3. Duties of persons having charge of animals. It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. Section 3 of the Act lays down the duties of persons having charge of animals, which is mandatory in nature, and hence confer corresponding rights on the animals. Rights so conferred on animals are thus the antithesis of a duty, and if those rights are violated, law will enforce those rights with legal sanction. It makes it mandatory for every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. However, this view was taken by the court in 2014 when the amendments to the Act were not made, wherein these sports have been introduced as an exception. Now coming to section 11 of the Act. Section 11(1)(a). Treating animals cruelly. If any person beats, kicks, overrides, overdrives, overloads, tortures, or otherwise treats any animal so as to subject it to unnecessary pain or suffering, or causes or being the owner permits any animal so to be treated. Or, now we'll be coming to clause M. Solely with a view to providing entertainment, confines or causes to be confined any animal, including tying of an animal as a bait in a tiger or other sanctuary, so as to make it an object of prey for any other animal, or second, incites any animal to fight or bait any other animal. Then the punishment is also laid down here. He shall be punishable in case of first offence with fine which shall not be less than 10 rupees but which may extend to 50 rupees, and in case of a second or subsequent offence committed within 3 years of the previous offence with fine which shall not be less than 25 rupees but which may extend to 100 rupees, or with imprisonment for a term which may extend to 3 months or with both. So section 11 of the Act lays down punishment for treating animals cruelly. Section 11 is a beneficial provision enacted for the welfare and protection of the animals, and it is penal in nature. Being penal in nature, it confers rights on the animals and obligations on all persons, including those who are in charge or care of the animals, such as Animal Welfare Board, etc., to look after their well-being and welfare. However, again, this view was taken by the court in 2014 when the amendment to the Act was not made. At that time, the court held that rights guaranteed to the bulls under Section 3 and 11 of the Prevention of Cruelty to Animals Act 1960, read with Articles 51A, Clause G and H of the Constitution, cannot be taken away or curtailed, except under sections 11(3) and 28 of the Prevention of Cruelty to Animals Act, and the Tamil Nadu regulation of Jallikattu Act was found repugnant to the Prevention of Cruelty Act, which is a welfare legislation, and hence held constitutionally void, being violative of Article 254, Clause 1 of the Constitution of India. Since Jallikattu was regulated by a state act, the bench held that this state act was repugnant to the provisions of the 1960 Act and it was held to be void. Now, thereafter, the amendments were introduced: the Prevention of Cruelty to Animals Tamil Nadu Amendment Act and the Prevention of Cruelty to Animals Maharashtra Amendment Act and the Prevention of Cruelty to Animals Karnataka Second Amendment Act were enacted by the respective state legislatures and had received presidential assent. In the constitutional bench judgment, the court held that the bulls form a distinct species referred to as draught or pack animals as opposed to horses, which are adapted to run. But it declined to hold that merely because bulls lack the natural ability to run like a horse, The subject sports, that is Jallikattu, Kambala, and Bullock-Cart Racing, which are seasonally held, shall be held to be contrary to the provisions of the 1960 Act. Thereafter, the court held that Constitution does not recognize any fundamental rights for the animals and tested the legality of the three amendment acts against the provisions of the 1960 Act, along with the constitutional provisions of Articles 48, 51A(g) and H. It was held that the amendment acts are not a piece of colorable legislation. It relates to entry 17 of list 3 of the 7th schedule of the Constitution of India. It further held that Jallikattu has been going on in the state for last few centuries, and whether it is an integral part of the Tamil culture cannot be decided by the judiciary. Since legislative exercise has already been undertaken and Jallikattu has been found to be a part of cultural heritage of Tamil Nadu, the court did not disrupt this view of the legislature. In the 2014 judgment, these sports were held to attract the restrictions of sections 3, 11(1)(a) and M of the 1960 Act because of the manner in which it was practiced. Now, the Amendment Acts, read with the rules, seek to substantially minimize the pain and suffering and continue with the traditional sports. The Tamil Nadu Amendment Act does not go contrary to Articles 51A(g) and 51A(h), and it does not violate the provisions of Articles 14 and 21 of the Constitution of India. Hence, the Honorable Court in the Constitutional Bench judgment allowed the conduct of these sports and held them to be valid. I hope you've understood the judgment and found the discussion to be fruitful. Thank you for watching. See you next time.